Good morning. This is an open meeting of the United States Securities and Exchange Commission on June 22, 2011. Today we will consider adopting a series of rules that implement the core provisions of the Dodd-Frank Wall Street Reform and Consumer Protection Act as they apply to investment advisors. First, we'll consider rules to facilitate the registration of advisors to hedge funds and other private funds. As part of this, we will also consider rules reallocating the regulatory responsibility for smaller advisors between the SEC and the states. Second, we will consider rules establishing for certain advisors new exemptions from the SEC's registration requirements. And third, we'll consider a rule defining what constitutes a family office. We will be jointly considering the first two items on the agenda, and after separate votes on those two matters, we'll consider the third proposal regarding the definition of family office. We begin with the registration of hedge fund and other private fund advisors who previously have been able to avoid such registration because of a statutory exemption that applies to advisors with fewer than 15 clients. The Dodd-Frank Act eliminated this exemption, making it clear that hedge fund advisors and other advisors relying on this exemption should no longer operate beyond regulatory oversight. As a result, many of these private fund advisors will now register with the Commission and be subject to its rules, its regulatory oversight, and examination program. Today's rules will fill a key gap in the regulatory landscape. In particular, our proposal will give the Commission and the public insight into hedge fund and other private fund managers who previously conducted their work under the radar and outside the view of regulators. Among other things, the rules we are adopting today will facilitate the registration of advisors to hedge funds and private equity funds and provide the SEC and the public with information about the business operations of these advisors, as well as information about their conflicts of interest, disciplinary history, and investment strategies. Also, our rules will require these advisors to detail the size and strategy of their hedge funds and other private funds, as well as the identities of critical gatekeepers, such as auditors and prime brokers that provide services to the funds. In developing our registration rules and reporting requirements, we sought to obtain from all these advisors a meaningful collection of data that would aid investors and assist our regulatory and examination efforts without requiring disclosure that could inadvertently harm the interests of private fund investors. In acknowledging the Commission's limited examination resources and in light of the new responsibilities for private fund advisors, the Dodd-Frank Act also reallocated regulatory responsibility for certain smaller investment advisors to the state securities authorities. Under the law, advisors with between $25 million and $100 million of assets under management are directed to register with the states if they are subject to examination by state securities authorities. Today's rules implement this provision. While the Dodd-Frank Act imposes new registration responsibilities upon advisors to hedge funds and many other private funds, Congress exempted from registration advisors solely to venture capital funds and advisors solely to private funds with less than $150 million in assets in the United States. But at the same time, Congress mandated that these advisors be subject to reporting requirements. In developing a reporting regime for these exempt but reporting advisors, the Commission is following a balancing approach. We are seeking information on key census data about the firm, its private funds, and any disciplinary information. But we chose not to require the full panoply of information, including the ADV Part 2 client-oriented narrative disclosure that would be required of a registered investment advisor. This is the Commission's first time developing a reporting regime for advisors that are exempt from registration. Thus, it is important that we assess our reporting requirements for these advisors once we have experience receiving the information and can fine-tune the information we collect at that point. I therefore am directing the staff to reconsider the information we collect from exempt but reporting advisors after we receive and assess the first year's filings. This will enable the Commission to make any adjustments that are necessary if we are not receiving sufficient information from these advisors. In addition, although the law enables the Commission to examine these exempt but reporting advisors, we do not intend to conduct routine examinations of them. As many observers know, the Commission has scarce resources and it is important, therefore, that we target those resources toward the advisors that are actually registered with us, where the investing public expects us to be focused. At the same time, if there are indications that we should conduct an on-site visit of an exempt but reporting advisor, we legitimately and appropriately will have the ability to do so. To give effect to the venture capital provisions of the Dodd-Frank Act, the SEC is required to develop a definition of venture capital fund. Our definition distinguishes venture capital funds from hedge funds and private equity funds by focusing on the lack of leverage of venture capital funds and the non-public startup nature of the companies in which they invest. The rule therefore focuses on the provision of capital for the operating and expansion of startup businesses rather than buying out prior investors. In crafting the definition of venture capital fund, our goal was to develop a definition that provided an accurate and legitimate definition of venture capital fund without including loopholes that could be inappropriately exploited down the road. While many commenters supported the proposed definition, others believed there needed to be some level of additional flexibility to accommodate unexpected situations or a limited number of non-conforming investments. Many commenters suggested various carve-outs for particular types of investments. To accommodate the need for some flexibility without unduly complicating the rule, the definition provides a 20% basket that would be outside the strict venture capital-oriented investment parameters imposed on the remaining 80% of the fund. This 20% basket would enable legitimate one-off investments and flexibility while maintaining a fund's core venture capital nature. Today's rules also provide clarity on the parameters of the foreign private advisor exemption and the exemption applicable to advisors solely to private funds with less than $150 million in assets under management in the United States. And finally, while not the subject of today's deliberation, the Commission will supplement the rules we are adopting today with consideration of adoption of a new form, Form PF. As proposed earlier this year, Form PF would provide additional information from private fund advisors that would be reported on a non-public basis pursuant to the Dodd-Frank Act. The information would be used to inform the SEC and the Financial Stability Oversight Council about the systemic risk profile of private fund advisors and the private funds they manage. The private fund and related investment advisor provisions of the Dodd-Frank Act become effective on the one-year anniversary of enactment, or July 21st. As such, it is important that we adopt today's rules before then to provide both certainty and clarity about the new registration requirements and any related exemptions. However, to facilitate an orderly transition and enable private fund advisors to come into compliance with our rules, advisors will not be required to comply with these registration requirements until the first quarter of 2012. This will give us time to adjust the registration system to accommodate private fund advisors and the change in threshold for registering with the SEC versus the states, and it will also give advisors to hedge funds and other private funds time to develop compliance systems and provide registration information consistent with SEC requirements. I really want to thank those who contributed substantial amounts of time, energy, and effort in crafting this set of proposals. From the Division of Investment Management, Eileen Rominger, Bob Plays, David Vaughn, Dan Call, Penelope Saltzman, Jamie Eichen, Matt Golden, Melissa Roberts, Devin Sullivan, Jennifer Porter, Trom Newen, Michael Spratt, Brian Johnson, John Russo, and David Bartels. You all did an amazing job. This group was assisted by Mark Kahn, Meredith Mitchell, David Blass, Lori Price, Bob Bagnall, Jill Felker, Sarah Busher in the Office of the General Counsel, Craig Lewis, Jonathan Sokobin, Bruce Krause, Harvey Westbrook, Chuck Dale, and Matthew Caruth in the Division of Risk Strategy and Financial Innovation. And it's my pleasure to welcome Craig Lewis, the Chief Economist and Director of the Division, to the Commission table for the first time. I also want to thank Norm Champ, Jim Reese, Jackie Sturgill, Karen Stevenson, and Brian Snively in the Office of Compliance, Inspections, and Examinations, Mark Sharma in the Office of Investor Education and Advocacy, and Jeff Minton, Paul Beswick, and Jeff Cohen in the Office of the Chief Accountant, Bruce Carpati and Rob Kaplan in the Division of Enforcement, Linda Sundberg in the Division of Trading and Markets, and Jerry Laporte and David Beaning from the Division of Corporation Finance. I'd also like to thank my colleagues on the Commission and all of our councils for their contributions. And with that, I will turn it over to Bob Plays.